My name is Jonathan Svitak. I'm one of our attorneys here at Shannon Law Group. Um, we're going to talk to you guys today about SIRVA. It's by far the most common vaccine injury, not only that we see, but that gets filed in the vaccine injury compensation program. We've now grown to have we've had hundreds of these cases. I don't think it'd be hyperbolic to say that we're experts in SIRVA at this point. And with me today, I've got two of our other attorneys, Elizabeth Simek to my immediate left here, who joined us in September of 2023, and then Elizabeth Hess at the end of the table here, who joined us in June of 2023. I'm sure you may have even been introduced to them in your own cases. So I'm going to turn it over to Elizabeth Simek here. She's going to kick us off and talk to you a little bit about the initial process here in a SIRVA claim.
Great, thank you. Welcome, everybody. Thank you for joining us today. As John mentioned, my name is Elizabeth Simek, and I'm going to talk to you about what happens from the moment you get your vaccination, you start experiencing your symptoms, reaching out to us, and then getting your claim filed. So first, filing a SIRVA claim in the VICP. SIRVA, what is that? That's a shoulder injury related to vaccine administration. VICP stands for vaccination or the Vaccine Injury Compensation Program. That is a federal program to assist people like yourselves who've encountered a vaccine injury. So the steps that I'm going to walk through are the vaccination and onset of your symptoms. The vaccination, once you get that, as we all know, it's not uncommon to have a little soreness, tenderness once you get a vaccination. The SIRVA symptoms, the onset of that is when those symptoms last longer than normal or more painful than normal. Now you know there's something that's unusual. That would be the SIRVA symptoms. So once you have your vaccination and experience those symptoms, you might, self-treat, taking over-the-counter medications, pain relief, whatever the case might be. Maybe you'll get to a point where you reach out to let me fast forward our slides here, actually, I don't know how to do that. You might get to a point, thank you. You might get to a point where you realize I need to reach out to a medical provider. So you contact your doctor, primary care doctor, or you're at some other medical appointment where you mention the fact that your shoulder has been hurting you since you got a specific vaccination. Not all providers are familiar with SIRVA. So, it depends on what they advise you, how they advise you to treat the symptoms that you're experiencing. But as time goes on and you realize that your symptoms are not resolving, many of our clients get to a point where they start researching what they're experiencing. Shoulder symptoms that have occurred after a vaccination. And then upon their research, they come across our lovely firm, Shannon Law Group, realize that this is something that we handle and reach out to us. Upon reaching out to us, a lot of times you'll be speaking to individuals by phone who will start asking you questions such as what the vaccination is that you've received, what your symptoms are, how long you've been experiencing those symptoms, any medical treatment that you've received. And if it's been less than 6 months since you've started to experience these symptoms, we'll let you know that we'll follow up with you in a 6-month period of time, because this government program, the VICP program, requires a 6-month severity requirement, which means that your symptoms have lasted for at least 6 months. The exception to that would be if you received surgery, and Elizabeth can talk more about, what's entailed with actually moving forward with resolving your claim, whether there's surgery involved or a non-surgical recovery. So once you have reached out to us, if it has not been 6 months yet, one of the important things is that when you receive your continued treatment, you might be encouraged to reach out to your doctor, ask about whether an MRI is necessary, cortisone treatments, whatever the case might be. What's really important is that any continued treatment you do receive, you consistently refer back to the fact that the symptoms started after you received your vaccination, because we want to create a relationship to your symptoms being caused once you received the vaccine. It's also important that any recommendation we provide you, whether it's an MRI, asking your doctor about certain types of treatments, making sure you go to see your doctor, make sure you're not saying that you're involved in a case or that your attorney recommended that you do these things. You want to make sure that this is something you're pursuing on your own, because we don't want to get into a situation where we can add some complications to resolving your case successfully. So do you mind forwarding the slide to the next one? After the 6 months have transpired, you'll receive a follow-up call from our firm where we'll provide you with a detailed intake form, and that is a historical summary asking about your background, where you got the vaccination, what vaccine it was that you received, the onset of your symptoms, what those symptoms were as time went on, whether it be within a month, 6 months, who your treating providers were, both prior to receiving the vaccination as well as throughout the entire treatment of your injury, and any witnesses that you might have to offer who can provide insight on the injury you've suffered and how it's affected your life. It's a very detailed form. Many of you may have already received that and completed that, so you know generally what I'm speaking about there. Once that intake form is completed and you provide that to our office, this is what I like to call as the background, what you don't really see going on, but there's a lot of magic that goes on once you turn in that form. A lot of work goes in, because what we will do then is we will reach out to the providers that you have listed, and we request all your medical records. Now, the government requires that the medical records we request are medical records starting 3 years prior to your injury through present. The reason for that is they're trying to determine whether there's any prior existing condition that might explain the symptoms that you have encountered upon receiving the vaccine. So this process takes a very long time of requesting the records and getting them in our hands. So the patient's factor of patience is really a big component throughout this whole process. There may be times that we might ask for your assistance in getting your medical records if we encounter difficulties in securing those. But again, the key is just be patient, because as soon as we get those, what we need to do is then review and abstract them. So depending on how many providers you may have, that will determine how long it will take to get the records and actually go through them. And we literally read through all of your medical records to determine what your health history is, to determine what visit dates you've had with the various providers, what was discussed at those visits, whether there were any pain medications or other specific treatment that was prescribed for you to follow to address your injury. And we will make a list of all that information, an abstract actually of all that information that we can use as an outline to help us as we develop the petition that we'll ultimately file with the court. The petition, that's your initial petition, that is a legal document that we file to begin the process of your case with the court. And within that petition, it's an outline of your story. It talks about your prior health history, the event of the vaccination, the symptoms you've occurred, how it's affected your life. And as we develop that petition, we rely heavily on your medical records. There are many things that we use to help develop your case. However, the medical records are really a resource and an exhibit that the court relies on heavily in determining what kind of symptoms you've experienced and how you've treated those. So that petition is the initial document that we will develop using those medical records, relying on the abstract that we've put together, and as well as your petitioner affidavit, and put that together and file that with the court. Once we have that filed, and this process, just to give you a general idea, because medical records can take quite a bit of time to receive, it can take months from the time that you have reached out to us initially to when we actually get your medical records. Then, depending on how many records there are to abstract, it could take a significant amount of time reading through all those and getting a full understanding of your experience, and then putting that together in the form of a petition. Once that petition is filed, we then will be working with you to develop your PAR form and your petitioner affidavit. You're the petitioner. So what is that petitioner affidavit? That's the more human element of your case. The petition, as I mentioned, relies heavily, we'll cite a lot to your medical records to tell your story. I like to refer to the petitioner affidavit as the more human element of your case, to really let the court know, opposing counsel know who you are. What were you like before the vaccine? What was your life like? Your interests, hobbies, all those things that make you you. And then what your experience was getting the vaccine, the injury you occurred, and then how that affected your life. Mobility restrictions you've had, pain you suffered, any effects on your life, inability to do things you used to love doing, any effect on relationships, all those types of things that really personalize your story. And then the PAR form, what that is that is a list of all of your medical providers. And what the court requests us to do is to provide a list of the providers that have treated you 3 years prior to the injury through the date of filing that form. And it doesn't matter whether it's a SIRVA provider or if it's a provider that you've met with throughout your injury, such as like an eye doctor or a dentist, anything along those lines. You might wonder, why do I have to do that? Well, what they're looking for is, have you ever mentioned your shoulder injury or the symptoms to a provider other than a primary care provider? And that just also helps us as your attorneys really drive home how impactful this injury has been if you're mentioning it to an eye doctor, for example. Then with that, we have a statement of completion. And what that is a single legal document that we file with the court after filing everything else, your petition, your affidavit, your PAR form, and all of your medical records. We put together the statement of completion. And once that's filed, that alerts the court to the fact that they are now ready to review your file because we've submitted everything we need to in support of your claim. Now, once that statement of completion is filed and that activates or lets the court know they're ready to review your file, it can take quite a bit of time for the court to actually, what I refer to as like activate your case. I look at it as once it's filed, you're in this queue of cases that they're going through looking at to determine whether you meet the requirements to stay within the VICP program and activate your case to move it to the SPU. That's a special processing unit, which is something that is been created to help expedite or more timely handle these claims. And I laugh when I say timely or expedite because that's not the case when we're dealing with the government. It takes a very long time. So that might, that could be months depending on how backlogged the court is. Completely along the way, we keep our clients informed so you'll know exactly where things are at. And once they do activate your case, they will instruct opposing counsel to file a status report, letting the court know how they wish to proceed with your case. They determined that so with this vaccine program, when we submit your petition and we file your claim, it's a claim against the Department of Health and Human Services. It's not a lawsuit. You're not suing a doctor. You're not suing the vaccine administrator. It is something that is brought against the Department of Health and Human Services, and they are represented by DOJ, Department of Justice attorneys. So once the statement of completion has been filed and your case is activated, the court assigns a Department of Justice attorney to handle your case. They work with HHS to review your file and then determine how they wish to proceed. And they may determine that it's appropriate for compensation. They concede entitlement. They may determine that they're open to settlement negotiations. They haven't necessarily conceded entitlement, but they're willing to have a discussion about awarding you damages. Or they may decide that you are not entitled under the program, in their opinion. Then with that, we then move on to my colleague, Elizabeth Hess, who will talk about what happens with those next steps. Thank you.
Yeah, hello, everyone. My name is Elizabeth. I'm the second Elizabeth in the room. So I'm going to be talking to you about how we prove entitlement in SIRVA cases. First of all, I need to let you know that there are what's called on-table cases and off-table cases. The great majority of our SIRVA cases are on-table cases. When we can prove that a case is an on-table case, entitlement is presumed if we can meet certain criteria for these cases. One of the things that we need to do to prove entitlement in a SIRVA case is to make sure that the vaccine is a covered vaccine under the program. The table does list all the vaccines that are covered vaccines in the program. The most common vaccines that we see in our program for SIRVA injuries are influenza, like seasonal influenza vaccines, tetanus vaccines, MMR, varicella, hepatitis vaccines, and some pneumonia vaccines. Some vaccines that are not covered by our program are COVID vaccines, and we do receive a lot of calls about injuries related to COVID vaccines, but they are not included in the VICP program. Shingles vaccines and some I cannot pronounce this, pneumococcal vaccines are not covered vaccines under the program. So in order to prove entitlement in a SIRVA case, an on-table SIRVA case, you do need to make sure that your vaccine is a covered vaccine. The second thing I'm going to talk to you about is the 48-hour rule. So you need to be able to prove that your symptoms from your vaccine injury occurred within 48 hours of you receiving the vaccine. Some ways in which we can prove that that you meet that requirement is to show that you experience pain or range of motion limitations in your shoulder. Oftentimes, people don't go to seek treatment within those first 48 hours of the vaccine because they feel like it might be normal to have a reaction to vaccine, that pain is normal and it can last for a time. Some people try to wait it out. They try to self-treat their injury. So how do we prove that you meet the 48-hour rule? Sometimes we can use affidavits in which you, the client, or other people, witnesses, people that you know, can testify to the fact that you complained about pain within that first 48 hours. Maybe they had been with you when you received the shot and you said, wow, my arm really hurts from this vaccine. It's just not normal. Sometimes you can prove that the symptoms started within 48 hours if you go to seek medical treatment and you refer back to the vaccine as the cause of your injury or the cause of your pain or symptoms. One of the issues that sometimes occurs with the 48-hour rule is like a delay in treatment. So in other words, if you're waiting months before you actually have an initial visit with a doctor related to your treatment, sometimes the respondent can say that that's too long, that there's no indication that the pain started within those 48 hours. Sometimes there can be a record that states the pain started at a different time, like with outside of that 48-hour time period. So there are different ways for us to be able to prove that you had pain within those 48 hours. And those were just a few of examples. In terms of the severity requirement, like Liz said, you have to show that you've had symptoms and have been treated for 6 months from the date of your vaccination. That's why it's always important to make sure that you're seeking treatment for your injury within that 6-month period. If you fall a little bit short of that 6-month period, it can be another red flag to the opposing side to say, wow, they have not been treated for 6 months, and therefore their injury hasn't lasted 6 months. In that case, it might become an issue with proving entitlement if you can't prove that you've been seeking treatment for at least 6 months. Statutes of limitation for this program, for the VICP, first of all, statute of limitation means that you have to be able to file your case within a certain amount of time or you're barred from filing the case and seeking compensation. In this program, you have to be able to file your case within 3 years from the date that you started having symptoms from your shoulder injury. If there's a death involved, then it's 2 years from the date of death. So you have to also prove that, you have to actually file your case within the statute of limitations in order to be entitled to receive compensation in this case. In terms of treatment, one thing that is required under this program is that you can't have any prior injuries to your shoulder that would in any way indicate that your current issue with your shoulder doesn't necessarily relate to your vaccine, but relates to maybe a prior injury. For instance, in a case where maybe a year or two prior to the vaccine, you had a tear in your shoulder, and then you had your vaccine and had issues, but sometimes that prior injury might be a cause to barring entitlement or there being a dispute with entitlement in your case. So, okay, so if we switch so now I'm going to be talking to you about possible outcomes for on-table SIRVA cases. And I know Liz kind of mentioned some of this to you. Once everything is filed and once the opposing side has had an opportunity to look at your records and review them and make a decision on your case, they can either concede entitlement in your case. That's the top thing there, conceding SIRVA entitlement. This means that you have met all the criteria under the program for a SIRVA table injury. In this case, the court will presume that the vaccine caused the injury, and the government will concede that you're entitled to compensation under the program. If that's the case, usually the only thing that you need to deal with is damages and what are the value of the damages in your case. Litigated risk SIRVA cases are cases where the opposing side believes there's some issues in your case that might not show that you've met all the requirements for entitlement. They might say that there was a prior injury. They might say that there's been a gap in treatment. They might say that you don't meet the severity requirement or the 48-hour onset requirement. But regardless of that stance, they're still willing to enter into settlement discussions in the case. They're willing to resolve the case. So basically, they won't concede entitlement, but they're willing to resolve your case and to possibly come to a settlement with you. The last way in which the last possible outcome in a SIRVA case is where the opposing side disputes that you are entitled to entitlement and damages. In this case, the government usually states that it does not believe you've met the requirements under the law for a table SIRVA case. In this case, it doesn't mean your case is necessarily over, but it usually means that you have to go into a litigation phase of a case where we have to argue your case before the court, before the special master, which is like the judge in the case. Usually in those cases, written briefs are filed in the case. We would file a motion stating why we believe your case and all the facts in your case meet the requirements of entitlement. The opposing side would then respond to that, and then ultimately, it's the court's decision as to whether or not you've met entitlement for your SIRVA case. So, okay. So once there's a decision made by the opposing side as to where they stand in the case, usually the next step is that the petitioner files a demand letter. Their attorney will draft a very thorough demand letter, which basically lays out their stance in the case and why you would be entitled to compensation under the program. What's included in the demand letter? There's quite a few things that can be included in the demand letter, including a background of the petitioner, what their life was like before they received this vaccination, what they were able to do with their shoulder, if they had no limitations, if they were involved in sports, or they had grandkids that they used to play with. So there's usually some background information that kind of lays out what life was like for the petitioner before they received the vaccination. And then we also include in the demand letter some facts related to the vaccination itself, as to whether or not when you got the vaccination, you noticed that there was an issue with the shot, whether or not you thought the shot was given too high. We talk about that onset, whether or not you had pain within those 48 hours. We include in our demand letter any evidence. We can cite to affidavits, we can cite to medical records that show that you did indicate that there was pain or there was shoulder limitations within that time period, so that we can lay out a foundation for that onset requirement. Then we can go into, in the demand letter, very thorough review of your and timeline of your treatment from right after you had the vaccination all the way through the time when you've ended treatment, if you have ended treatment. Usually we have a very thorough overview of what you've gone through in terms of what you told your doctor, what tests were done for you, whether or not there was range of motion testing, whether or not you described some pain levels and things like that to your doctor. Doctor's assessments and diagnoses. Diagnoses can be put in that letter, and then plans for any future treatment. So we try to create a good timeline of what happened in your case with your shoulder injury, which would also kind of indicate why you should be entitled to compensation. We also like to include some information about the impact that your vaccine injury has had on your life. So this can include what you used to be able to do prior to the vaccination, what you can't do now since you've had the vaccination, whether it's just like activities of daily living. I can't bathe. I can't reach up on a shelf. I can't do daily chores. I can't drive a car. Things that I used to do, simple things that I used to do, I can no longer do, because of vaccine injury. We like to include information about how the vaccine injury has impacted your life. We also discuss in the demand letter not only entitlement, but damages, what we think your damages should be, and what facts in your case that actually prove how you've been damaged by your vaccine injury. Parts of the damages section of our demand letter include pain and suffering. What evidence shows that you endured pain and suffering, and to what extent? Out-of-pocket expenses. If you have paid out money for copays, for medical bills, prescriptions, things like that, that can be included in a demand letter in terms of damages. And lost wages. If you had to stop work, you had to live at work because of your vaccine injury, that also can be included in a demand letter. So basically, the demand letter tells the story of your vaccine injury and how it's affected your life. We usually do include an amount that we think that your case is worth. And once our demand letter is drafted, we do submit that over to the respondent so they know where we stand on the case and what we're expecting in terms of possibly in a demand amount and what your case is worth. The Rule 4 report, respondent's Rule 4 report, is basically kind of like a status report that they're required to file with the court that pretty much lays out their case. In your case, lays out whether or not they believe you are entitled to compensation or not. It has to set their full position as to why they think that's the case. They can include medical analysis based on how they read the records, what they see shows whether or not you had an injury. They can also set forth legal arguments as to why or why not they think you're entitled to compensation. The one thing they cannot do in the Rule 4 report is they cannot just be a general denial we don't believe you're entitled to compensation. They do really need to specifically set forth their stance and why they think you are or are not entitled to compensation. So that is it for me. I'm going to be turning it over to John now to continue.
Okay, great. Before I dive into my portion here, a couple of housekeeping things I should have mentioned from the start. We are recording this, so if you joined us late or you have to leave before the end of it, we'll provide a recording for those who missed this. And then our marketing specialist, Brittany, is behind the scenes right now. She's helping us with this. She's producing this. So she's also monitoring the chat. So if you have a question for us, hopefully you can use this the chat function to leave your question, and we'll get to as many of them as we can at the end of this. And two things I wanted to touch on that we've already talked about here. Two of the issues that we see quite a bit in these SIRVA cases with respect to entitlement is this 48-hour onset rule, and then the severity requirement. And when you experience an injury like this, there's and you go to your doctors and you're seeking treatment. There's only so many things that's within your control when you go to the doctor. You can't control the treatment that they prescribe or offer to you. You can't control what diagnosis you receive. That's up to the doctor. But in terms of the more subjective parts of medical records, onset is something that you can influence. You can consistently and repeatedly tell your doctors that your pain or your symptoms started when you got that vaccination. That's something that you can tell your doctor at every visit. And I continuously see in the judge's decisions, one of the factors that they look at is the petitioner consistently and repeatedly attributed his or her symptoms to the vaccination. So no matter which doctor you're seeing, if it's a physical therapist, a primary care doctor, or your orthopedic doctor, it may sound redundant, but just keep referring to that vaccination as when your symptoms started. Especially if for whatever reason there's a delay in your symptoms or in you getting to the doctor, or there's a gap in your treatment. Upon your return to the doctor, make sure they understand that this isn't some new injury. This is still a continuation of your vaccine injury. And then with the severity requirement, there's a difference between treatment and symptoms. All that we're required to show to meet the severity requirement is that your vaccine injury symptoms persisted for 6 months. So that doesn't mean that more than 6 months from the date of your vaccination, you need to be in some sort of active treatment, getting physical therapy or receiving a cortisone shot injection. It just means that you need to be reporting symptoms. And that's something within your control too. So, if you're still having symptoms, it's been more than 6 months from your injury, you may not necessarily need additional treatment, but the injury is still impacting you. It's still impacting the way you live your life. You still have pain. It's important you go to the doctor and report those things, even if, at the end of the day, they don't actually prescribe you any treatment. So those are two things where, you can actually help yourself, create the sort of evidence that we're going to need. And then to pick up here where Elizabeth left off, I can talk a little bit about, the litigation process and the briefing. The program is sort of limited in its trial aspect. Typically there's no hearings. You're not going to be asked to testify usually before the special master, and obviously there's no jury trials in this venue. So a lot of times what we're doing when we litigate is just simply filing a motion. And the motions can become very, comprehensive. Usually they're between 20 and 30 pages long. They go through all of your medical records, go through all the table SIRVA criteria, and painstakingly show why you meet all the criteria, why you're entitled to compensation. And then the government does the opposite. They file their own response, and they outline the reasons why you don't meet the criteria. And after that gets filed, what I like to tell my clients is I imagine a big stack of these motions on the judge's desk, and the one I just filed goes at the very bottom of his stack, and he's got to make his way through all of them before he gets to yours. Just recently I had a case resolved that we filed our brief a year and a half before he ultimately made his decision. So that's how long a case could be pending and waiting for a decision if we have to litigate, unfortunately. So the way that cases can end is through that litigation process. The judge finally making a decision and entering a judgment, with respect to your entitlement and damages, or through what we've already discussed, some sort of informal resolution like a settlement. And so either way, if a case resolves through informal resolution or through litigation, there's a judgment that's going to be entered. The judgment will be awarding our client compensation, hopefully. And then from there, it can take anywhere from 30 to 60 days for the Treasury Department to issue payment. So that's how these cases typically resolve. I thought it might be interesting to talk a little bit about some of the trends I've been seeing in these SIRVA claims. SIRVA itself isn't a new injury, but in terms of the vaccine injury compensation program, it's a fairly new phenomenon. The injury was just recognized as a table claim in the program in 2017. So we have some data now from when that injury was added to the vaccine program until now, and we can see how things have changed over the years. So we go to the next slide here. We've touched on this. Just I want to reiterate. This is a lengthy process. It can sort of be a winding road, depending on how the case resolves. Thing to remember is, part of the reason you get an attorney in these cases is because when the case gets to this point, where there may be money on the table in the form of a settlement, there may be issues that you face with entitlement. You need an attorney to know, what the litigative risk is if you're considering litigation, what the value of your claim is, so you can confidently either reject settlement or accept a settlement, and then have an attorney that can advocate for you, in litigation and file the appropriate brief or motion. But the biggest issue that I see with resolving cases is really a timing factor. We get to the point in some of these cases where there may be a settlement offer from the government. It may not be, most likely it's not going to be full value of your claim or your damages. And we can confidently tell you that you're likely to get more compensation from the judge. The court tends to be a little bit more generous than the government in these cases. But by signing up for litigation, you're also signing up for an extra 1.5 to 2 years in these cases. Some people, for them that doesn't matter. They want to see their day in court and they want to get full value for their injury. No matter what you decide, we're obviously prepared, for litigation or for settlement, and we're here to discuss those things with you so that you make a informed decision. Now let's look at some trends here. So this is from a case that was decided back in 2021. So we about 4 years into SIRVA being on the table. And at that point in time, there had been about 70 cases that the judge himself had reviewed and issued decisions on. So that first column you see is decisions from the special master. So the special master looked at these SIRVA claims and awarded these amounts. So you can see the lowest amount was just over 40,000, the median just under 100, and then the largest was actually over 265,000. Should mention here, there's a cap on pain and suffering damages, no matter what your injury is in the vaccine injury compensation program, and that is 250,000. So that's for pain and suffering only. So if you have an economic type, injury or damage in terms of lost earnings or wages or out-of-pocket medical expenses, there is no cap on those damages. So that can exceed the $250,000 cap. That middle column is what we call a proffer. Now, these are cases in which the government is not disputing that you're entitled to compensation. So, they aren't trying to get you to accept something less than what they consider to be full value of your claim. As you can see, though, the government tends to have a lower value on these cases than the court does. So in 2021, the lowest proffer was 25 grand. The median was less than what the court was awarding at 90. And then the largest proffer, which obviously included some sort of economic component, was 1.8 million. So again, these are cases in which the government reviews it. They can't identify any issue as hard as they try. They can't poke a hole in your case. So they just offer you what they consider to be full value of your case. And those would be accepted by petitioners. The last column is what we call stipulations. And this is where we get into the settlement portion. So this is where the government does identify an issue with your case, but they want to try to resolve the case with you. So in this instance, they're offering you less than full value of the case. And these petitioners, for one reason or another, have decided to accept that settlement. So you can see 5,000, the lowest, the median was 65,000. Now we can see 4 years later how these have changed. So this is a decision that came out just recently, March 19th of this year. We've got about 200 more decisions from the judge, about 1,200 more proffers, and about 1,800 more stipulations to look at here. As you can see, the numbers are trending downward. The court is awarding lower amounts in pain and suffering or in damages. The lowest was 40 4 years ago. Now it's 30. The median was 97. Now it's 89. For proffers, they've fallen significantly. The lowest is 5,000. Median has dropped from 87 to 80. And in stipulations, this is where we're seeing a major trend from the government, offering very, very low settlement amounts on these cases. The lowest being 1,500 and the median at 50. So you can see, over the last 5 years or 4 years, we're starting to see the government especially become more difficult to work with on these cases, which has coincided with an uptick in litigation because our clients are rightfully not accepting these amounts that the government is offering. So that's just a snapshot here of the last few years of how these cases are starting to trend, and why, again, it's smart to have an attorney here to help you navigate these things. Finally, I don't know if this will be interesting to anybody, but I want to show some general data from the vaccine injury compensation program, where we can see, you can get an idea of. So this shows all the claims that have been filed in the program since 2006, when influenza was added to the vaccine injury compensation program. This is how many doses have been administered, and then you can see how many claims have been filed relating to each of these vaccinations. So as you can see, quite a few doses of vaccines are administered, have been administered over the last 20 years, and not that many claims have been filed. So, despite us, representing hundreds of these petitioners in these cases, it's still quite rare to see, a vaccine injury, even a SIRVA injury. I do think that, SIRVA is a little bit underreported. I'm sure there are many people out there that have experienced SIRVA that don't end up pursuing a claim. But this gives you an idea that, the numbers are pretty low in terms of claims in the vaccine injury compensation program. Here you can see the number of petitions that have been filed every year since the program started. A couple of things to note here is, as you can see in 2017 and really in the start of 2016, we see a huge uptick in the number of petitions that are filed every year. And that, obviously coincides with when SIRVA was added to the program. Again, it's by far the most common injury, that we see. So that also meant a kind of a slowdown in processing these claims, because the resources at the Department of Health and Human Services, at the court, did not change, and the cases basically tripled. So that has also led to a backlog in cases, and has led to many delays that our clients have experienced in prosecuting these claims. We're starting to see things pick up a little bit. Another issue that popped up was in 2021, the Department of Health and Human Services actually proposed to remove SIRVA from the vaccine injury compensation program. And that led to a bunch of claims being filed, hoping to preserve their right to get compensation for a SIRVA injury. You can see there's kind of an outlier there of over 2,000 claims filed in 2021. And that also led to a significant backlog that the court was trying to work through. And you can see here, in 2024, we see all the claims that were actually adjudicated, and there's a very large number there in 2024, which is all of the cases that were filed in 2021, to beat the clock. So they definitely worked through a lot of those cases, but that also gives you an idea of how long these things take. All those cases that were filed in 2021, weren't adjudicated until 2024, 3 years later. So this is a lengthy process. And like Elizabeth mentioned, patience is key. Trust the process, and that, we've got your best interests at heart. Let's see if we'll share. Okay.
I just want to apologize to everybody. This is Brittany. I realized the chat was disabled throughout the webinar. So now we're going to move into the Q&A portion, and you can submit your Q&A portion directly to the panelists by clicking the Q&A button towards the bottom of your screen. And then you can just type your question there and send it directly to them, and it will appear on their screen.
While we're waiting for questions, a couple of things I just wanted to make note of, to make sure that you were aware, because I've received these questions from some of my clients. So these might be questions you also have. As John mentioned, and Elizabeth did as well in her presentation, when we present the cases to the chief master, should they be litigated, we do not need to fly. You would not have to fly out to DC. Everything is handled through us. So you don't have to worry about having to show up in DC. If your case ends up being litigated, your witnesses don't have to worry about having to go to DC and being asked to testify. We work directly with them to put their witness affidavit together. And once that's completed and filed with the court, they're done. It's a relatively painless procedure for witnesses, which I wanted to stress because witness affidavits are super important and can help really build your case. So it's great if you have witnesses, and sometimes they might be intimidated by the process. So please let them know there's no need to be intimidated because they don't have to go to DC or worry about being testified by the court or being interrogated by the court. The other thing is when your case is settled, the compensation that is awarded is yours 100%. You do not pay us any attorney fee. Our attorney fees are paid directly through the court. So once your case is settled and you accept that damage award, that is your money 100% to keep. Also, if you are feeling better, you get compensation should you meet the requirements of SIRVA. So just for the fact that you no longer have the issues doesn't mean you can no longer have a case, provided you meet all the requirements. That is something I wanted to make sure you knew too. And the final point is 2 books that I wanted to highlight. These were authored by John. Great books. If you don't have them, I encourage you to reach out to the firm and ask for a copy. You can receive these for free. It's great information that talks about SIRVA and processes, et cetera. So if you have any more interest other than what we've talked about today, definitely request copies of those books. Thank you.
Okay, great. Looks like we have a couple questions here from some attendees. I'm going to ask the first one. The first one is from Rick. He says, since all this started, my doctors were very confused as to what is going on. They started looking at other things that were not from the injection. These other tests are looking away from my initial injury. What can I do?
Thanks, Rick. This is something that we encounter quite a bit, especially with doctors who are unfamiliar with SIRVA and are looking for some other explanation for your symptoms. Again, the thing, really the only thing you can control is explaining to whoever you're seeing the onset of your symptoms was with the vaccination. And then, do your best to, describe your symptoms, as accurately as possible. Sometimes, when we experience an injury like this, it can feel like your whole body hurts. And one thing that the government loves to do is to try to confuse, what symptoms are, correlate to the injury or to your shoulder, and what, symptoms may not. Sometimes our clients have overlapping symptoms, if they have a neck issue or a back issue. So, do your best to, again, always attribute your symptoms to the vaccination. And then as accurately as you can, describe what symptoms were actually, related to that initial vaccine injury. And then, if you're still not getting, a sense that your doctor is accurately diagnosing you, there's nothing wrong also with getting a second opinion. If you need to. The court is not going to look down on the fact that, you jumped to a new doctor. And worst case scenario, if there is some sort of confusion over your diagnosis, if you meet all the other criteria, we do have the option of, using an expert, an outside specialist to clarify, what your diagnosis is, and whether it meets SIRVA or some other, injury.
Great. All right. Thank you, John. Thank you, Rick, for the question. Next, we have a question from Pete. He says, what's the best way to check on the status of our case with your office?
Thank you. Pete, you said it's Pete, thank you for the question. The best way, should you have questions about the status of your case, definitely feel free to reach out to the office. If you know who your assigned attorney is, a lot of times once we get your records and start working on your case, we'll reach out to our clients, introducing ourselves, letting them know that we're the ones managing their case. You can always, whether it be text or phone call, but what we do is we try to make sure that our clients don't have to be the ones reaching out to us first, that we keep them up to date on the progress of their case. Every time we get an update from the court or should we have any questions outstanding from medical records, we need your assistance. We'll definitely be in touch with you to keep you informed. But don't hesitate at any point if you have a question or you just want to check in. Definitely feel free to reach out, because it's important that we keep an open line of communication so that you feel like your case is being properly handled, and we know that you are informed along the way, so that should we need any additional information from you, you're not caught by surprise and we can keep things moving forward.
And I would add to that there's never a reason why you shouldn't call us. If you have any questions whatsoever, if you have different issues with your shoulder, if you're seeking new treatment, we are always here, to answer questions and to hear what you have to say. We just want to make sure that we're listening to you, that we have all the information about what you're going through in terms of your case. Even if you're having other issues in your life that are coming up in terms of new symptoms or struggles with this or that. I know that our office does send out pain journals that allows you to write down what you're experiencing on a daily basis. With your shoulder injury, that's a great way to keep track of it. But definitely, the more we share and communicate with each other, the more we can represent you, fully in your case.
Great. Thank you. Thank you, Pete, for the question. Next, we have a question from Demetrius. He says, how soon after the 6-month wait after the injury does one file an affidavit? When should I send updated doctor's visits?
So once you've reached 6 months from the date of your vaccination, first of all, we'll reach out to you with some instructions about what's going to happen next. What we're looking for is confirmation that you still have symptoms, that you either have already seen your doctor or planning on seeing your doctor. And then once we confirm that, hopefully you will have either begun working on the intake form or, have completed the intake form. And so we know who your medical providers are. We can immediately begin requesting all those medical records. But we typically don't start working on, the petition or the affidavit until we have, at least a majority of those records in, because we want to be able to incorporate some of that information as well, and make sure that it's accurate. So sometime, within, a few months or so following the 6-month, severity requirement threshold, we'll reach out to you to at least begin discussing the petition and the affidavit. It may be that you've followed up with your doctors again, and we need to get updated records. But it's sort of an ongoing process, once we cross that 6-month threshold.
Okay, great. Thank you, Demetrius, for the question. Next, we have a submission from one of our attendees. They say, if you had surgery from the vaccine, does that matter, or does that increase the reward damages?
So I would say definitely the more treatment that you have, different things like pain levels, extent of treatment. In terms of surgery, there's different things that you can have in terms of surgery, different types of maybe they're repairing a rotator cuff tear, things like that. That definitely adds to the value of your case. especially when it comes to the respondent and opposing attorneys. They like to see what the actual treatment is in your case. They value the case based mostly on what's in the records, and the treatment that you received. And surgery definitely is a big one. It does can add a lot to the value of your case.
I would like to add, adding value to your case is never a reason to get surgery. That should be a decision you make after talking to your doctor and being confident that that's the best, course of treatment for you. Don't go getting any unnecessary surgeries because you might be adding, value to your case. But generally speaking, yes, surgery or the duration of your symptoms, the extent of your treatment, the government tends to sort of count up your visits and what you experienced, and that's how they derive value of your claim.
Great. All right. We have another question from another attendee. They say, I just received a call from my gynecologist about requested medical history. They just wanted to know what it was about. Should we be giving any heads up to our doctors that this request is coming?
For the medical requests, you can, if you want to let them know. Heather, one of our paralegals here, she's in contact with the clients because you will need to complete a HIPAA form since your medical records are, private. The government requires that you sign a HIPAA form allowing us permission to access your medical records. So you can let those providers know, but not everyone does let the providers know. It's not unusual for a provider to get a medical record request, and a lot of times it doesn't even go to the provider. It goes to their medical records office. So the provider doesn't even realize that you're requesting your records. So it's up to you whether or not you want to let them know. But when we do submit those requests, it's very detailed as to what we're asking for. It doesn't say anything about you're involved in filing a claim for SIRVA injury, but we do let them know what specifically we're looking for. And I guess it depends on you whether you want to keep your provider informed, but most providers don't even know that the medical records are being requested because their medical record office handles those requests.
Something that's really important to point out is in the VICP, this is a compensation program, so there's no liability for the person who's given you the vaccination or the hospital or your doctor. So if they're ever worried that you're asking for records because they think they're in some sort of trouble or there's a liability issue, that is simply not the case. This program and anything that's paid out in this program is all through federal funds, and there is no liability on the administrator of the vaccine or the facility or the doctor.
Okay, great. All right, thank you for submitting that question. We have a question here from Ralph. He says, what qualifies as a witness affidavit? Can I collect handwritten comments from friends, for example, that have had some exposure to or awareness of my injury?
For the witness affidavit, what we do, you would provide the names of the witnesses who you would like us to contact for purposes of putting together a witness affidavit. But what we do is we put together a questionnaire that we submit to them to answer those questions. And it will talk about, what you were like prior to vaccination, when did they become aware that you experienced this injury, anything that they've observed in terms of how the injury has affected you, your life, limited mobility, pain levels, anything along those lines. So there's a questionnaire that they would be filling out. And once they submit that to our office, and they can do it directly, or if you want to work through, have the witnesses provide it to you and you provide it to us, then what we do upon reviewing that is put together an affidavit using that information. Most times we're in contact with those witnesses to make sure we understand what they've provided and ask for any clarification or any additional information so that we can develop a robust affidavit for them to review and sign. So whether it be your affidavit that we're preparing or your witness affidavit, once we draft that, we always get your approval before it's signed and submitted. So they'll know exactly what it says, and if there's anything they want to change or they're not comfortable with, it's their document too. So they need to be comfortable with it before they sign it. So it's not separate individual notes. It's an actual legal document that is created, but that's how we develop it, is this questionnaire that they would complete.
But just to add to that, the questionnaire is there's no limitations on that. So, if they have been taking notes or something like that, we'll collect any information, from witnesses that they want included in the affidavit. And then, I don't like to place any limitations on who you want as a potential witness. Keep in mind some of the issues that we've talked about during this presentation. Being 48-hour onset or severity. Think of witnesses in those terms. Who might have been around you either during the vaccination or immediately following the vaccination, who might recall how that pain progressed over the first few days, or who was around you at 6 months from the date of the vaccination, who can attest to the fact that you were still experiencing symptoms. So think about who might be the most compelling witnesses for those issues.
Great. All right. Thank you. Thank you, Ralph, for the question. Next, we have a question from Paul. He says, "I'm just entering 6 months from my initial flu shot. My condition is getting worse. I only have partial mobility in my right arm. Do you guys do representation? Do representation or go after do you guys do representation for going after the entity that administered the vaccine?"
So no, we typically only pursue claims through the Vaccine Injury Compensation Program and do not pursue any liability cases or civil cases outside the program. I have from time to time, encountered people who, wanted to pursue a civil case against the administrator or the facility where they got the vaccination. There are ways to do that, through exiting the program, meeting certain criteria. There's limited causes of action you can bring against a vaccine administrator or a provider. But if that is something that you are interested in, I definitely would give us a call because we can talk to you about maybe some alternative options that you have.
Great. Thank you, Paul, for the question. We have one more question from an attendee. They say, "My witness is my spouse, and they live out of the country right now. We have saved conversations from the 40 hours after the vaccine was administered and the pain I experienced. Will you need to talk to them, or can those saved conversations be useful?"
Yeah, this is an excellent question because it will let me talk about sort of the rules of evidence in this program. They're not as strict as your typical civil case, so we can file almost anything as evidence, and we have on many occasions filed text messages, we've filed Facebook posts, we've filed anything that has a timestamp on it, emails, especially if they're within that 48-hour window. I mean, that would be very strong proof that you're experiencing symptoms that early. So yeah, if you have text messages or other correspondence that's saved and time-stamped, we would certainly want to say not only for 48 hours, but also for severity, or if there are gaps in your treatment, that can sometimes close those gaps. If you think of a question that you didn't get a chance to ask, can always reach out to us, with an email or a call, and we'll get back to you as soon as we can. You guys have anything to add?
No, just thank you so much for joining us and thank you for choosing Shannon Law Group. Look forward to working with you.